Court TV again, they couldn't wait. They had that motion hearing, and they jumped right on it. And they bring in the usual suspects. All three of them are criminal defense attorneys. And after listening to them, you now know why half the damn country is locked up in jail. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnnie Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnnie Walker Dredd Show.
Poor Vinnie Politano, he can't get a break. Every time he tries to host this show, he has to herd the attorneys onto the evidence because they clearly haven't been following the story. Let's go ahead and start her up.
That's the story. Does it sound like self-defense? Bring back in the think tank. Ian Friedman, does that sound like self-defense?
Well, I got to tell you, as you said, the most divisive case, but the defense lawyers have done a good job really limiting what this case is going to be about, the self-defense. Could it be? Sure. It really is going to depend on this evidence. The more narrow the defense lawyers can keep this, the better. If we start.
Ian Friedman really wants Kyle convicted. And so he's conceding here that it could be self-defense. That's a big admission.
Getting into why he was there and so forth, it becomes more problematic. But this case will really be, could be, depending upon how the lawyers present it, a case study and a real analysis on self-defense law. Because one has to believe that they have a reasonable fear of imminent bodily harm against them or someone else. Now, one could argue, well, yeah, particularly as we just heard, if he's defending against someone who's coming at him. But then the other side of it is you can't come to that situation. You can't be the cause of it. So
that's technically not true. There is no prescription that you can't be the cause of it. Why? Because Kyle fled the scene. He may have caused the whole commotion, although there's no evidence to suggest it at all. But regardless, once he flees the scene, he gets to reassert his self-defense rights. So I don't understand why Ian Friedman is making this mistake here.
Him coming to it is going to be an issue also. This is really going to be a very legal, factually driven assessment for this jury. The lawyers will love to listen to all of this. It's a very interesting case as to how this will go down if you just look at the law and you keep out all of the other stuff which the defense lawyers have to do in this case if they have any chance of being successful.
Brian Watkins, there was an allegation in court today also that Joseph Rosenbaum said in front of the defendant that if I get you alone, I'm going to kill you.
That's very damaging evidence if that comes in. Of course, the propensity of violence by the victim is always relevant in a self-defense case.
Well, here's the thing. What he is saying is true. If it's found or if evidence surfaces that Joseph Rosenbaum threatened to kill Kyle, that's a big deal. And the defense can use that. But notice something. He's not even going to spend any time on it. He's going to change the argument immediately. Listen.
Here we have the propensity of violence by the defendant.
Oh, the propensity of violence by the defendant. So never mind that whole thing about Joseph Rosenbaum threatening Kyle, whatever. Yeah. Let's talk about the propensity of the defendant. That's what he wants to talk about. This is a defense lawyer. How would you like to have this person defending you?
And what's key here in this case here is that he can only use deadly force if he's threatened with deadly force. It can't just be imminent bodily injury. It has to be great bodily injury and or death.
False. And the other attorney is now going to correct him.
The bottom line here is you can't use a gun in a fist fight. So if that guy's coming at you and you think he wants to fight you, you still can't shoot him.
That's also not true. You can't use a gun in a fist fight. Yeah, you can, under certain circumstances. The law doesn't have anything in there that says anything about not being able to use a firearm against fists.
And so if those are the facts laid out by the defense, yeah, go ahead.
Yeah, I don't know if I totally agree with you on that one.
In other words, you're wrong. That's what he's trying to say. He's just being polite. The attorney on the bottom right, that's Brian Watkins, he defended Kellen Winslow, who pled guilty to rape and some other things.
I still think it's going to be a question for the jury as to whether or not he reasonably believed for the fear of his safety. I agree with you on the definition, but I still think it's a question that goes to the jury. So it's not an absolute, as you know. It's just going to be whether or not the jury believes his actions were reasonable in that case. And we've all seen instances where one punch dropped and killed somebody. So it
Exactly. So he basically came in and said, look, it's not at all about whether the threat was real. It could have been a completely imaginary threat. The only thing that matters is, did Kyle believe that he faced serious bodily injury, and was that belief reasonable? Whether the threat was real or not, irrelevant. And that's what the law says.
really is going to be an issue of reasonableness for this jury.
How about if he's grabbing the gun? What if he's going for the gun, Brian? What if he's going for the gun? I've got a gun and he's going for my gun.
Notice that Vinnie Palatino has to direct the lawyers onto the fact because they don't know anything.
Well, technically, he has the right to go for your gun because you don't have a right to point the gun at him. He hasn't done anything or presented a weapon to you. So we can go back and forth. So
See, he doesn't know what happened. He's under the impression that Kyle, for no reason, pointed his gun at Joseph Rosenbaum, and Joseph Rosenbaum, trying to protect himself, tried to grab the gun. That's not what happened. Joseph Rosenbaum is chasing him. Kyle is trying to flee. You can't compare those two situations.
I have the right to slap your face. You can't shoot me because of it.
I have the right to slap your face, and you can't shoot me because of it.
If you pull a gun on me and you don't have the right to pull a gun on me, I can disarm you. And if you defend yourself against me disarming you, you don't have the right to shoot and kill me.
All right, Bernarda, I only have a time for one word answer from you.
Good, because that's about all she can do.
Is it self-defense, yes or no? Or possibly?
Well, Rittenhouse is going to have to testify for us to say.
What? Okay, let's be clear. In every state now, Ohio was the last holdout, but Ohio has changed its laws recently. In every state, self-defense is an affirmative defense, and the burden of proof is on the prosecution. Kyle does not have to take the stand. I doubt he will. The only time that he will take the stand is if some real damning evidence comes out. Then he's going to probably have to. Maybe that whole FBI plane thing might change things a little. We'll see. But to come out here and just say, well, he has to take the stand, she doesn't understand the law. And she's a criminal defense attorney. Yeah, that's great. How would you like to have her defend you? You go to prison and then find out, wait, I didn't have to take the stand? My attorney told me that I had to take the stand. So, yeah, I don't know where they get them. Like my video, subscribe to my channel.